Hello, this is Paul Callahan. I'm the head of the Employment and Pensions Group at Taylor Wessing, and welcome to our webinar to discuss holiday pay. The recent case in the Employment Appeal Tribunal, which came out about 2 weeks ago, of Fulton and Baird, Scotland, is potentially one of the biggest changes to UK employment law as a result of interpretation of statute for some time. Now, as listeners may well know, minimum holiday entitlement is something that has been set down by the EU in the working time regulations, and it's considered a health and safety issue. And as a matter of law, all employees working in the UK need to take at least 28 days holiday per year, potentially including the 8 public holidays. And it's always been the case that employers would pay simply normal base salary when an employee took their holiday. This case, for the first time, has made it absolutely clear as a matter of binding law that that's not good enough, and that certain other types of payments do need to be included when calculating holiday pay. And we're going to go through the issues in some detail and what you ought to be doing now, and essentially what this means for your business and what you can afford not to do, the areas where you need to wait and see. So what's important to be aware of is that this case doesn't cover all overtime. It simply covers certain forms of non-guaranteed overtime, and my colleague Anna McCaffrey is going to go through that in more detail. The case is going to be appealed at least once, and probably more than once, from the court to the Court of Appeal, then the Supreme Court, and then it might go back to the European Court of Justice again. But there are some key issues that the Employment Appeal Tribunal has made clear are unlikely to be successfully appealed, so you need to be aware of those now. And in a way, for a lot of our clients, this is merely a forerunner to the even bigger case, which is due to be heard in February, which is going to determine whether employees who regularly receive commission as part of their remuneration are going to have the commission that they've received taken into consideration when calculating holiday pay. And the thought is that that's likely to go in favour of employees, and that, needless to say, will have very major ramifications and costs potentially for those doing business and their sales employees in particular in the UK. So handing over to Anna. Anna's going to go through some of the greater detail as to what sort of overtime is covered by this case.
Hello everyone, my name's Anna McCaffrey. I'm a Senior Associate in the Employment team, and as Paul mentioned, I'm going to go through in a little more detail the types of overtime that are covered and those that aren't. So starting off, there's 3 different categories of overtime in the case law at the moment. The first category is what we call guaranteed or compulsory overtime. This is where the employer is obliged by contract to offer overtime to employees and to pay the employees for that work, even if they don't actually need it, or if the employee is not actually called on to perform it. And equally, the employee does not have any right to turn down the work. Given that it's guaranteed, guaranteed overtime essentially becomes part of an employee's normal working hours and normal working pay. So unsurprisingly, that would be seen to be so linked to their normal hours of work and their normal contract of employment that it's all linked together. And so therefore we've known for some time that guaranteed overtime must always be included in the calculation of holiday pay. The second category of overtime is what's called non-guaranteed overtime. This is a type of overtime that the Bayer case was concerned about. It means that the employer doesn't have to offer any overtime, so it's not compulsory and that it's not guaranteed by the employer. But in the event that the employer does decide to offer overtime, the employee is required to work the overtime. So it's not guaranteed on the employer's part, but there is a requirement by the employee to carry it out if they're offered it. And the main implication of the Bayer case is that for non-guaranteed overtime, the Employment Appeal Tribunal confirmed that has to be taken into account in relation to calculating holiday pay. The third category of overtime is voluntary overtime. So this is where an employer is not required to offer the employee any overtime, and equally, even if overtime is offered, the employee is not required to work the overtime that has been offered and has a right of refusal. Whilst the Bear case made it quite clear that the middle category of non-guaranteed overtime must be included in the calculation of holiday pay, the case was silent on voluntary overtime. Therefore, as things presently stand, it's not certain that employers have to include voluntary overtime in the calculation of holiday pay. Voluntary overtime, or at least officially voluntary overtime, will of course be very common in most workplaces. Therefore, there's two approaches to this. Given the uncertainty on the issue, employers could take the cautious view that it's legally safest and probably easiest for calculation purposes to include voluntary overtime in holiday pay calculations, and in order to begin limiting exposure to any future claims for historical underpayment of holiday pay. However, the disadvantage of this approach is that, at least until the law is clarified in this area, employers that choose to take that approach may be paying more holiday pay than they actually need to. As such, other employers will choose to accept a small portion of risk and not include voluntary overtime in their calculations at present, at least until this point is appealed. Employers who take that approach, whilst they're limiting their holiday pay costs, do take on a few risks which is worth taking into account before deciding what approach you want to take. As Paul mentioned, there is likely to be further litigation in this area, and the point on voluntary overtime is likely to be taken up at some point when we see further cases in this area. Given the direction case law is going, we are of the view that if the voluntary overtime point comes before the Employment Appeal Tribunal or the higher courts, it's very likely that the outcome will be that it's confirmed that holiday pay should also include voluntary overtime that has been worked. Even in the meantime, until that point is clarified by a higher court, there's also a risk that given the uncertainty, in practice, first instance employment tribunals, if they're presented with a grey area or a question as to whether or not you should include voluntary overtime in the calculation of holiday pay, may take quite a cautious interpretation of the Bear case and decide that it did include voluntary overtime rather. Whilst that might be debatable as to whether that's correct in law, given where things are moving in this area, there is a bit of a risk there. Thirdly, probably what is quite difficult in practice is to distinguish between what is genuinely voluntary overtime and what's non-guaranteed overtime, which was the middle case that the Bear case talked about. And this is particularly a risk where, in practice, employees always work the overtime that is offered to them, whether or not they theoretically have a right to refuse or not. And when you're getting to the stage that the overtime worked, whether it's officially voluntary overtime, turns into such a settled pattern that it's quite hard to distinguish between other types of overtime. In those cases, it's probably quite risky not to pay, not to include that calculation of overtime in holiday pay. And so it's probably quite prudent to make sure that even if you decide not to include voluntary overtime in holiday pay at the moment, to make sure you have good kind of monitoring practices in place so that you can identify cases where overtime is worked so regularly that it becomes a bit of a risk area. I'm just going to very quickly touch on another difficulty with the current case, which is even if we accept that overtime should be included in holiday pay calculations, how do you go about identifying the appropriate reference period for the calculation? The first point to note is that including overtime payments in holiday pay is limited to the first 4 weeks of statutory holiday. The 1.6 additional leave portion, which makes up the full 5.6 statutory minimum we have at the moment, the new overtime rules don't apply to that. So really employees will in practice get paid more for the first 4 weeks of statutory holiday and less for the 1.6 weeks, unless of course an employer decides to include overtime for all holiday pay calculations. The EAT did say that it would adopt the approach that the first 4 weeks of leave an employee takes in any year will be deemed to be the 4 weeks, and any after that will be the 1.6 additional leave. But obviously, differentiating between those two can itself cause administrative and monitoring difficulties. The second challenge is that the case did not really discuss in detail how the calculations would operate in practice. and it didn't actually state which reference period should be used. However, in the absence of any other guidance, our view is that most employers will adopt a 12-week look-back period, given that that's what's referred to at the moment in the working time regulations. This means in practice that you'll have to consider, before an employee takes any period of holiday, whether or not they worked overtime in the preceding 12 weeks, and if they did, that should be included in the calculation of their holiday pay. Obviously that can cause a bit of an issue in relation to your monitoring and administrative practices, but also it does also lead to the risk of employees perhaps scheduling a period of holiday to coincide after a period of particularly heavy overtime, because under the current rules you would make a financial benefit on that. I'm going to hand over now to my colleague Suzanne, who's going to go into a bit more detail about how we deal with the risks in relation to past underpayments and what the views on that are going forward.
Thank you, Anna. My name is Suzanne Tyrrell and I'm a Senior Associate in the Improvement Team. As Anna mentioned, I'm now going to cover the part of the case dealing with other allowances, as well as the extent of an employer's exposure to the cost of backdated claims. In addition to overtime, the judge in this case considered whether various other payments made to employees should be included by employers in the calculation of holiday pay. The main additional payments considered were travel payments. The two key travel payments were a radius allowance and a travelling time payment. In both cases, the original tribunal held that the radius allowance and travel time payments were not to be included in pay for annual leave for the purposes of Regulation 13 of the Working Time Regulations. The Employment Appeal Tribunal considered this point again. Looking at the payments in more detail, a radius allowance was paid to any employee who travelled between his or her home and a site over 8 miles away. The allowance was for travelling time and also for fares. The radius allowance was only payable for 4 days with work. HMRC treated some of the radius allowance as a reimbursement of travelling costs, with the balance as taxable remuneration. The part of the radius allowance which was for fares and which was not taxable remuneration did not form part of normal remuneration and was therefore excluded from holiday pay calculations. The travelling time payment entitled employees to be repaid for time spent travelling at the rate of 1 hour of basic pay for the first 30 miles travelled and half an hour for each subsequent 20 miles, in each case considering a one-way journey. The judge held that both the taxable part of the radius allowance and the travelling time payment should be included within the calculation of holiday pay. These two allowances were for time spent travelling, and they should not be thought of as an expense ancillary to travel, such as a train ticket or bus fare would be. The key analysis was that time spent travelling is not a cost, it's time spent which is linked to work. This approach is in line with the European Court's decision in Williams and British Airways, which established that normal remuneration included components of pay which were intrinsically linked to the work done by an employee. So what does this mean for other contractual allowances? How can an employer determine whether an allowance should be included in calculating holiday pay? In summary, the factors employers should consider are: is the allowance taxable remuneration? If not, there may be an argument to exclude this from holiday pay calculations. How bound up is the allowance in the job that your employee does? If the allowance is intrinsically linked to the work the employee is doing, then there's a strong argument that the allowance should form part of holiday pay. And look at the custom and practice in paying the allowance. Have you been paying this over a long period of time? If so, this could mean that the allowance should be included within holiday pay. Taking a couple of specific examples and applying these factors. What about a daily lunch allowance up to a set amount to pay for lunch purchase? Here, the payment appears to be for an expense incurred, and it's not intrinsically linked to the actual work the employee is undertaking. Therefore, it's arguable that the payment should be excluded from holiday pay. And what about a car allowance for an office-based employee, which is effectively a non-pensionable salary supplement? In that case, the allowance is not linked to a specific cost, but is normal remuneration for the day-to-day work undertaken by the employee. So there's a good argument that it should be included in holiday pay calculations. I'm now going to move on to consider the extent of an employer's exposure to the cost of backdated claims. A key concern for employers is how far back an employee can make a claim for historic deductions in holiday pay, due to the failure to include overtime and/or allowance payments. There had previously been concern that if this case was decided in the employee's favour, then employees would be permitted to bring claims dating back to 1988, which was when the working time regulations was introduced. This could have been a serious concern for many employers, as the potential liability could have been considerable. Fortunately, the EAT has now given guidance on this point and determined that claims for back pay are more limited. A tribunal uses jurisdiction to consider a complaint that there's been a deduction from wages unless it is brought within 3 months of the deduction or the last of a series of deductions being made, i.e., in this case, when underpayments for holiday were paid through payroll. This means that an employee only has 3 months from the date of the last underpayment to bring a claim for the balance of the holiday paid. And as already mentioned that there are 2 types of statutory holiday leave, this distinction is particularly relevant to the issue of back pay claims. The first part of statutory holiday is a 4-week period, also known as Regulation 13 leave. I will refer to this as basic holiday. The second part is the additional 1.6 leave, 6 weeks, also known as Regulation 13A leave, and I will refer to this 1.6 weeks as additional leave. As Paul mentioned right at the start, each employee in the UK is entitled to both basic and additional holiday, which together add up to an annual entitlement of 20 days in total, plus 8 bank holidays. This case considers the impact of non-guaranteed overtime on the calculation of holiday pay for basic holiday only, so that's the first 4 weeks of statutory holiday. Employees are still permitted to restrict holiday pay to basic salary only for the additional holiday, that's the 1.6 weeks, and also for any contractual holiday in excess of statutory holiday. An exception to this is where an employee has overtime, which is both compulsory and guaranteed. If that's the case, then the position remains that holiday pay is always included overtime. The Employment Appeal Tribunal held that the first 4 weeks of basic holiday of each holiday year are caught by the requirement to make any necessary adjustments to holiday pay. The later additional holiday and any contractual holiday are entirely unaffected. The Employment Appeal Tribunal also considered the public policy behind the deductions from wages legislation, which required claims to be made promptly within 3 months unless it's not reasonably practicable. Therefore, a series of deductions punctuated by a gap of more than 3 months would mean that the tribunal would not be permitted to claim unless there were other valid mitigating factors about why the claim could not be brought in time. The EAT then held that whether or not there's been a series of deductions is a question of fact, there would need to be sufficient subject matter such that each event is factually linked with the next in the same way as it is linked with its predecessor. There should also be a sufficient frequency of repetition. In this case, the deductions were not sufficiently linked. This means that an employee no longer has the right to determine whether a period of annual leave is basic or additional leave, and use this to his or her advantage in evidencing a series of deductions, thereby permitting him or her to bring a deductions claim for a longer period of deductions, or which otherwise would have been out of time. The effect of this part of the decision is that employees are much more restricted in their ability to evidence a series of deductions. On a final note, you might be wondering if this is the final position. At the moment, we don't know for certain if the case is going to be appealed, but it's likely. And if it is appealed, this is likely to be on the basis of the back pay period and whether or not it should be extended. It's not likely that the 3-month back pay period will be reduced, though. Now, I'll hand over to Rosalind, who will discuss the pensions implications of this decision.
Hello, my name is Rosalind Connor. I'm a partner in the pensions team here at Taylor Wessing. The pensions issue in relation to this particular change in employment law relates to the fact that most pension scheme contributions by employer and employee are generally presented as a percentage of pay. Most schemes will talk in terms of basic pay, in gross basic salary, and in those terms you would generally expect that this type of payment, which is fluctuating, would not fall within that category. Although the jury is still out on that, it is not entirely certain. The general view is that on a basic pay calculation, you wouldn't include these awards. However, for anyone who's auto-enrolled, they will be aware that the standard basis for auto-enrolment, unless you use an alternative structure, involves using effectively all cash remuneration, so that in any event, overtime and other payments will fall within that. It's worth bearing this in mind because if there are retrospective claims, it may well be that members will be obliged to make good any contribution they would need to have made out of that money into the pension arrangement. It's also worth bearing in mind if your pension arrangement doesn't say basic salary as the basis for your contribution. Other definitions of pensionable pay, which are found in occupational plans, or indeed more widely, will start to be affected by this decision. If we do get a decision that the time limit is going to be extended backwards in terms of the payments that people receive, it could be quite a substantial amount of money for individuals to contribute into the plan and for employers to contribute as well. What we've seen from previous pensions cases where there have been claims for past contributions that have been missed is that there is also an obligation on the on the employee to make their own past contributions, and if they're unwilling or unable to do so, then the employer does not have to do so. We haven't, of course, got a decision on that in this case, but we would expect that you'd be able as employer to demand that employees make their own contribution. I think the short answer of this is that if you are making a back payment to an employee, you should keep in mind whether you want to retain any money out of that to make it their payment into the pension scheme, and if so, make sure you've had the necessary conversations and communications with them first. So from a pensions point of view, there is always inevitably a wrinkle here not to be forgotten, but for once it's not the major issue here, which I think remains the potential cost for a vast number of employees in relation to holiday pay arrangements and overtime. I'm going to hand back at this stage to Paul to conclude where we've got to.
Okay, and if anybody does have any questions that they'd like to ask, do write them on the screen. We still have a few minutes. Essentially, the question that most people want to know is, what should you do now? And of course, that's not straightforward. It's perfectly respectable if you decide to do absolutely nothing if none of your employees have been raising the issue, because in a way, until somebody raises it and brings a claim, you don't necessarily have to comply with this ruling. It is good law now, though. The rulings of the Employment Appeal Tribunal are legally binding, and so the legal position currently is what this case says, which is essentially that where you do have non-guaranteed overtime, but if you're in a workforce where it's normal to require people to work overtime when you offer it to them, then they probably are entitled to this. Now, needless to say, from having listened to Anna and how you calculate this, I appreciate that it's going to be incredibly complicated, because it means that every time somebody goes on vacation, at least for those first 20 days, which adds another complication, that you effectively have different rates of pay for different types of holiday. You are going to have to go back and work out how much overtime they've taken, and then average it out over the 12 weeks to decide how much they have to pay. Needless to say, payroll providers are already working on providing a software product to do that. Now, the advantage of changing now and accepting that this is the way that you have to treat non-guaranteed overtime going forward is that it will potentially break the limitation period in relation to any back claims, because as the law currently stands, employees only have 3 months, as Suzanne rightly said, from the last date of underpayments, so the last date they were paid for holiday at their basic salary rather than their overtime rate. So if you now start going forward and paying what is now the higher correct rate, if that applies to your particular workforce, then unless they bring a claim within 3 months of their last underpaid holiday, you ought to be free in relation to back pay. That comes with a massive caveat that it is that limitation period that we're expecting to be one of the biggest focuses of the next appeal of this decision. But in truth, although you may well be concerned that you have big back pay claims, and you may have big back pay claims, as soon as there is a gap of 3 months or more from the last time that they took their first 20 holidays in a year, that ought to break the limitation period and you ought to be free. So as I say, you can do nothing, or if you have employees who clearly come into this category, you can rectify things going forward, knowing that this particular principle in relation to having to add in an allowance for overtime to their holiday pay is unlikely to change, even if the back pay rules do change. Now, I'm just going to look to see if we have any questions. And Anna, would you like to take one of the questions?
Yeah. So somebody's asked a very sensible question of, can we avoid all this by using time off in lieu instead of paid overtime? I think the short answer is yes, you probably can. And that what this case is concerned about is what a week's pay is, and making sure that what you're paid whilst you're on holiday is what you should have been paid, or what a fair week's pay is, taking into account things like allowances and non-guaranteed and guaranteed overtime. And what I suppose time off in lieu is essentially saying you won't be paid for overtime, but if you work overtime, you can take more time off work. So I think if you look back over a period when people do overtime, then if they've taken time off in lieu, instead of being paid an hourly rate for that overtime, their week-to-week pay won't vary, which means that you don't have to vary the holiday pay calculation necessarily. Of course, the downside to taking that approach is that whilst your holiday pay cost overall may not change, you will have people that have a right to take more time off work, which may or may not cause operational problems, particularly if they're allowed to take the time off in lieu when it suits them best, as opposed to when it suits the employer best. But certainly that's one way that might have if it's used sensibly, might be a way of limiting the impact if it's something that works for you operationally, of course.
Okay, thanks for that. Suzanne is going to deal with another question.
Okay, so the question is, if the employee is paid an hourly attendance allowance for each day worked, which is currently deducted when they take holiday, are they now entitled to have this included in their holiday pay? Really good question. So I think the answer to this is probably yes, and we need to look at the three kind of key factors that I discussed before. Is the allowance taxable remuneration? I'm assuming it is. And how bound up is the allowance in the work that your employee actually does? Is it intrinsically linked to the work they do on a daily basis? Here it looks to be the case, so that's another positive factor indicating that it should be included. And finally, I'd look at whether or not there's a custom and practice of making this payment too, because that could also add weight to the argument that it should be part of their holiday pay. So overall, if my analysis is right on those points, then I'd look to be including it in their holiday pay going forward.
Okay, and another question. Do you agree there are far-reaching implications for unlawful deduction claims in general, having the EAT conflated the 3-month limitation period and the gaps between the series points? And I think that's a fair question to raise, and I think that's probably one of the reasons why most people expect the appeal to focus particularly on the back pay and the limitation periods, because the rule is that you have to bring a claim within 3 months of the last in a series of deductions. So arguably, you could have very big and irregular gaps between that series. So actually, provided somebody did bring a claim within 3 months of the last underpayment, why can't they go back to 1998? Is a very good question. Okay, and then one final question that we've had, which Anna's going to deal with.
We've been asked if there is any guidance on what will be deemed regular overtime and normal take-home pay, particularly thinking of scenarios where someone may only work an hour or two here or there, or may work a lot of overtime over a busy period such as Christmas. I think one thing to start off with here is, before we look at what regular overtime would be, is you still need to go back to the basics to to classify what type of overtime we're talking here. If it's non-guaranteed, i.e. the employer doesn't have to offer it, but when they do, the employee has to work it, it doesn't matter how often or how little they do it. If they have to work it as and when it's offered, even if they don't do it in practice very regularly, it should still be taken into account in relation to holiday pay. Where it becomes more difficult is if the overtime itself is voluntary, so the employee doesn't have to say yes, but in practice doesn't ever say no, even though they could do, then this is where we get into a bit of a grey area, which might mean that if there's a settled pattern of overtime, that you should be paying that. I think in relation to this example, I think if it's genuinely voluntary and someone can say no, and they only happen to work overtime during busy periods, such as over Christmas, then I don't think that falls into a settled pattern. So I think ad hoc hours here and there, or overtime over a period such as Christmas, which is quite limited, in itself is unlikely enough to be to kind of recharacterise voluntary overtime as non-guaranteed. But unfortunately in this one, you probably do have to take a bit of a case-by-case analysis approach.
Okay, thanks for that, Anna. And we've run out of time, but you have on the screen all of our names and email addresses. So if you have any further questions, feel free to contact us. Needless to say, this is a very fast-moving area of the law, and within the next 12 months, things may have changed enormously. So do stay in touch. Thank you for joining us. I hope you found it useful.